Going to call to order the City of Sherwood Planning Commission meeting for May 24th, 2022. Roll call
Chair Simpson,
here.
Vice Chair Kai,
Here.
Commissioner Vance.
Here.
Commissioner Montalvo. Here. And Commissioner Wydola and Commissioner Lampros are absent.
Thank you very much. Consent agenda consists of the approval of the May 10th, 2022 regular meeting minutes. Their motion,
I move we approve the meeting minutes or the consent agenda. Second.
it's been moved and seconded to approve the consent agenda. Are there any comments? I did turn in a typo to the staff prior to the meeting. All right, all in favor, say aye.
Aye. Aye.
Aye. Opposed? Motion carries. Council liaison announcements. Councilor Giles, welcome.
Thank you. Let's see, so we don't have a ton of announcements today. We've got Cruise in Sherwood. Please sign up to volunteer if you're interested. It is June 18th coming up, and we have a number of other opportunities for volunteering. But other than that, we've been pretty light on. We've been doing some legislative matters and things like that. So nothing of really concern here. We heard the work that you guys did on the housing types at our last meeting, and it went very well. I think there's a few wording changes and things like that, but other than that, it was very well received. Thanks for your effort on that. And that's all from me.
All right. Thank you. All right. Moving on to staff announcements. Erica?
Good evening, Commission. So it's sad to report, after 17 years of Planning Commission meetings, Community Development Director Haiduk will be leaving Sherwood. She's accepted a new position with the City of Staten as City Manager, which
Yay!
such a great opportunity. But I do want to let you all know we are having a little open house for her next Wednesday, June 1st from 2 to 4 in the afternoon in this room, and feel free to stop by. And Julia, would you like to say anything?
Not really, but thank you very much. And especially Chair Simpson knows that, I started out in planning commission is my heart, and I will miss all of you guys, and I'm excited to move on to Staten and see what I can do there, but we'll miss Sherwood and everybody here very much. And I singled you out because you were here since I started.
It's the beginning of time, and I will miss seeing you on the other side as if I'm starting to get myself in trouble, you rescue me. Yeah, Eric is starting to learn to throw me a lifesaver when I need it, so appreciate it much. You are missed, but what an asset to the city and state. So, congratulations.
And then our next regular commission meeting is on June 14th. And then we have 2 hearings scheduled for that night. And then on June 26th, as you know, I've kind of reached out to you already. It's a big hearing night that evening. And we're hoping to start at 6 o'clock that evening. We have 3 hearings scheduled. Or June 28th, sorry, not 26th.
So June 14th, there is a work session.
No, there is not.
Okay. So it's just a regular meeting at
Regular
7
7
p.m. June 28th is the 6 p.m. and that we'll have a quorum for the 28th meeting.
Correct.
That's always good. I just want to write it down because it's embarrassing. All right. Community comments. Community comments are limited to those items that are not already on the agenda. And in looking at the public blue cards, I don't have anybody signed up. So this evening, if you plan to testify either under community comments or for the public hearing, we ask you to complete a blue card and turn it into one of the staff members. I don't see anybody signed up for community comments, so we'll move forward to the next agenda item. Next item is the public hearing. And public hearing on LU 2021-009 Cedar Creek multifamily major modification is called to order. Sorry. This hearing has been continued from a previous night, and the staff will go through the details on that. The public hearing this evening will be conducted as follows. Staff will present the staff report. Questions, if any, by the hearing body for staff. We will then open the public hearing for testimony, and time will be limited as follows. Applicant will have 30 minutes split between presentation and rebuttal. Persons in the favor of the application will have 4 minutes each. Persons opposed to the application will have 4 minutes each. The rebuttal from the applicant is the remainder of their 30 minutes. Then no other testimony will be taken from the public or applicant unless the public testimony period is reopened. Final comments by staff, questions of staff, if any, by the commission, and then deliberation by the commission. A decision may be made by the planning commission at the close of the hearing, or the matter may be continued to a time and date certain. If the matter is continued to a date certain, this will be the only notice of that date you receive. Staff will recognize people who have signed up to speak 24 hours in advance to provide testimony virtually. When it is your time to provide testimony, please state your name and address for the record. If you are in the audience this evening and wish to speak, please fill out one of the blue testimony forms and submit it to the planning staff. The chair will recognize people who wish to speak. When you come forward, please state your name and address for the record and ensure the green light is on the microphone stand, which you have to press for about 3 seconds for it to turn on. Any questions should be addressed through the chair. In reaching a decision on the application, the commission must consider whether the application meets the relevant approval criteria in the city's land use regulations. Those criteria are identified in the staff report. Staff report is available online and at City Hall. Staff report was accessible to the public 7 days prior to this meeting date. Testimony and evidence must address these criteria or other criteria you believe to apply to the decision. Please note, failure to raise an issue with enough detail to enable the commission, the applicant, and the parties an opportunity to respond to the issues precludes an appeal to the city council or land use board of appeals on that issue. Also, failure by the applicant to raise constitutional or other issues regarding proposed conditions of approval, again with enough detail to allow the commission to respond to the issue, precludes an action for damages in circuit court. At this time, I would like to ask members of the commission to disclose any ex parte contacts, bias, or conflicts of interest. Please indicate the nature and extent of the ex parte contact, bias, or conflict of interest, and indicate whether you intend to participate in or abstain from the hearing. Seeing none, I would also ask, we have one commissioner who was not at the previous evidentiary hearing, and like to ask if you had an opportunity to review the materials prior to the hearing this evening.
Yes, I was sent the minutes from the prior 2 hearings and reviewed them prior to the hearing this evening.
Excellent. Does any member of the audience wish to challenge any planning commission members' ability to participate this evening? Hearing none, we will move to the planning staff report.
Good evening, and thank you, Chair Simpson and Planning Commissioners. Happy to be with you this evening. Eric Rutledge, Associate Planner here at the city, giving the presentation for LU 2021-009 Cedar Creek Plaza multifamily major modification. I'm going to go through, since this is a revised application, go through the whole summary kind of in detail again, just to make sure the audience and the commissioners are all kind of on the same page and hearing the same thing and as it's related to the revised proposal. So the applicant is proposing a new 67 unit apartment building in the Cedar Creek Plaza Center. The application is being processed as a type 4 major modification with the Planning Commission as the decision authority and City Council as the appeal authority. As I mentioned, this is a revised proposal. So the original application was for 84 units. on lot 2, utilizing the lot area from lots 3 and 7. Typo on that screen, sorry about that. Then the application and proposal in front of you this evening is for 67 units on lot 2 using lot area from lot 7. So the change is that lot 3 has been removed from the application and the lot area from that lot no longer included, which is why the unit count was reduced from 84 to 67. Everything else related to, so the building itself obviously changed, the exterior changed, the unit count changed, but the rest of the application remained the same in terms of the site plan, the building footprint, the landscaping, all of that stayed the same. So the change was related to the building design and the unit count. That changed some of the other findings related to traffic and parking, but again, the actual physical site plan itself did not change as a result of the reduction in units. Notice of the application was routed to affected agencies and their comments have been incorporated into the staff report. Public notice of the application was provided for the original and revised applications, including mailed notice to property owners within 1,000 feet of the site. We've received 22 pieces of testimony on the application from 9 individuals. So parties providing more than one piece of testimony in most cases. All of the comments were in opposition to the proposal. Here's the applicable chapters of the development code. Just as a reminder, as always, this is a quasi-judicial decision, so the decision needs to be based off of the approval criteria. If you have any questions on sort of the details of the code, and I'll go into some detail during this presentation, happy to dig into those in the staff report and discuss them prior to you making a decision. Since the release of the staff report last week, we've received 3 additional pieces of testimony, exhibits AP through exhibits AR. All of those have been sent on to the commission, and you have all of those in front of you today. We should have a few extra copies here in case members of the public are interested in reviewing that. Overview of the public comments, again, 22 comments. In opposition from 9 individuals, kind of a wide range of concerns, site plan, including the site plan review, major modification process, the use of residential use in a commercial zone, using lot 7 to support the unit count, ownership and use of lot 3 to support the unit count, parking issues, traffic at the main site entrance, noise, trash, and operations of the apartment building. And the staff findings on all of these items, except for using lot 7, is that the proposal meets the approval criteria. So staff hasn't seen any concerns with any of these issues, again, except for using lot 7 to support the unit count. As I mentioned, lot 3 has been removed from the application. And then we have, through the previous and continued hearings, heard questions raised by the Planning Commission, and that includes, does the application propose a density transfer, and does the code allow a density transfer? And this is the area where I think the change in the staff recommendation is coming from, is taking a really close look at our code as it relates to these questions. And so I don't know that we're going to answer them, specifically, but the staff report kind of sheds light on both of the questions, and that's kind of how we came to the change. And I did want to add that I know we have quite a few, going back to the testimony that was just received, quite a few letters from attorneys and from legal professionals. And so I think it's just important for you guys to know that the staff report was reviewed by our legal counsel, Josh Stoper, our city attorney, and also these questions specifically around density transfer, and does the code allow a density transfer? These were reviewed by additional legal counsel to the city, and that's where the change in the staff recommendation is coming from, is really getting legal input on these questions as it relates to our code. So the first thing we looked at, of course, was the code. And then the second that we're keeping in mind is compliance with ORS 197.307 regarding clear and objective standards for housing. So that was a bill you're not familiar, it was a bill that was passed by the state legislature in 2017 that requires the standards that are applied for housing to be clear and objective. And I'll share more on that as it relates to our findings in just a second. But and I do just want to acknowledge to the applicant and their team, that obviously this was a change in the staff recommendation. It's been a long application for them. Just want to acknowledge that. But at the end of the day, the city needs to staff needs to make a recommendation to you that, we feel is based in the code and also based in state law. So that's where the recommendation is coming from. To get into the details of the site and the proposal. So this is Cedar Creek Plaza. It's at the corner of Edie Road and Highway 99. The lots that are included in the application are lot 2. It's a vacant lot at the rear of the site. And then lot 7, which is a developed commercial lot here at the southern portion of the commercial center. In terms of existing conditions and the past land use history, the city issued site plan approval for Cedar Creek Plaza in 2017. The center currently includes 8 buildings with a mixture of office, retail, and assisted living. Lot 2, as I mentioned, is here at the rear of the lot, and lot 7 here at the southern corner. There's a fully signalized intersection here at Edie Road and Borchers. Then there's also a right turn in only from Highway 99 into the commercial center. The site is zoned retail commercial and surrounded by commercial zoning almost in all directions, northeast, south, with the exception of to the west, where there's a high density residential zone, which has been developed with townhomes. Getting into some of the core of the retail commercial code as it relates to housing and the staff recommendation. So the code says that multifamily is permitted in the retail commercial zones, subject to certain location and development standards. First, housing is required to meet the dimensional standards of the high density residential zone. This is the standard where the staff recommendation has a finding of denial. And then second, the housing must be on the upper floors and the rear of or otherwise clearly secondary to commercial buildings. And because the building is located behind all of the other commercial buildings on the center, the staff finding on that specific criteria is that it has been met. And I do want to clarify, the city did update the code as it relates to housing in commercial zones recently after this application was submitted, and that code does not apply to this application. We're reviewing the application against the code at the time the application was submitted, and so that's what you have on the screen here today. But it has been changed, but we are not applying any of those recent updates. Going into a little bit more detail, again, the code states multifamily housing is permitted subject to the dimensional standards of the HDR zone in section 16.12.030. And when you go to section 16.12.030, it's titled Residential Land Use Development Standards. In that table is Table C. And Table C includes these different standards, including minimum lot area, minimum lot width at front property line, minimum lot width at building line, depth, height, setbacks. And so the finding in the staff report is that because the use table, the RC use table references all of 16.12.030, all of these apply as dimensional standards. And so that's an important point, and I think discrepancy between the staff finding and the applicant's position. The applicant does acknowledge that through their application, all of these apply to lot 2. In their application, it applies minimum lot area, lot width at front property line, building line, etc., all for lot 2. However, when it comes to lot 7, only minimum lot area is applied. And so that's kind of a key issue with the staff sort of finding as it relates to the applicant's proposal is that they are only for lot 7 in this application, only discussing and talking about minimum lot area. So when we're looking at implementing our code in a clear and objective way, all of these other standards, become problematic. How are we applying lot width at front property line, building line, lot depth, et cetera, for lot 7? It's just not quite clear how that would actually work. And so that's one of the key issues that staff is seeing right now with the application. And I would add that the applicant has also provided a legal memo stating that 16.12.030 and the reference to dimensional requirements, that sort of entire code section is not clear and objective, and that because of that, it can't be applied. And so we've kind of heard two different things from the applicant, both that, all of these apply, including minimum lot area for lot 7, but we also have a memo that says none of it applies. And so, just from what we have on the record from the applicant, it seems clear that, there's, even in their own words, it's not really consistent. The city's position has been consistent over the course of this application on this issue, and that is that all of the dimensional standards under 16.12.030 apply to the application. The change in the staff report would be coming from how we interpret this specific lot area requirement, and that's where the change is coming. But in terms of what standards actually apply under 16.12.030, the city has been consistent saying that all of the standards under this table apply. And then one other important note, staff in the staff findings did not apply the density requirement under 16.12.010. And that was because in this RC table, it references 16.12.030, but does not explicitly reference 010 and density. And because of that, staff felt like we couldn't apply density to the application. If it was applied to the application, the unit count would be lower than it is right now. It's a little bit more restrictive than the lot area requirements. Just a little bit more detail on this to make sure we understand what's being proposed. So the code in terms of meeting the minimum lot area for HDR zone, the code requires 8,000 square feet for the first 2 units, 1,500 square feet for each unit thereafter. So the total required for 67 units is 105,500 square feet. The applicant is proposing to use lot 2, which has 75,000 square feet approximately, and lot 7, 30,000 square feet for a total of just over 105,500, which would demonstrate that they meet the minimum lot area for 67 units. And this is again where the findings of denial come in. First is that lot 2 includes an access easement. You kind of see this road here, which is an access easement. The code pretty clearly says that right-of-way and easement serving other properties should not be included in the lot area calculations. Those are included. So I just want to be clear that even if lot 7 was included in the lot area calculations, this access easement on lot 2 has not been removed, and therefore it does appear that the density would be exceeded just by not removing the lot area, which is pretty clear in the definition. And then the other issue that staff has raised in the findings is, of course, around lot 7, because it's developed and not contiguous to the vacant lot. And so the finding there is that it can't be used to meet the minimum lot area requirement. And then I just want to be clear on this for the record. So I've maybe 2 more slides on this, but the definition of lot is a parcel of land of at least sufficient size to meet the minimum zoning requirements of the code, and can be a single lot of record or a combination of complete lots of record. And the applicant argument is that lot 2 and 7 of the Cedar Creek Plaza Center can be, based on this definition, can be combined to comprise a single lot and meet the minimum lot area. As I mentioned before, it's not completely clear to staff how we would take into consideration all of the other dimensional standards, lot depth, width, et cetera, if we're using two lots that aren't contiguous. And then the second concern is that under this sort of broad application of the code, that two incontiguous lots really anywhere in the city, or if you have a really large site plan application with a subdivision, these lots could be very far apart. And under this approach, density would be able to be moved around. And we don't believe that that was the intent of this definition or of the code. And I know you'll see in the memo from the applicant, the recent legal memo, that staff in our interpretation has sort of inserted things into that definition to interpret it. I do just want to add that in the applicant's definition of that, of the lot and how to apply it, they are also saying that it should be viewed through the lens of an entire site plan or subdivision. It's not really clear if they're referring to site plan or subdivision. It seems like it's site plan, but again, that is not clearly referenced under the definition of a lot. And so I would just add that issue extends to their definition as well. But staff understands the parcel to mean one or more contiguous lots under the same ownership. Under this application of the code, the city would be able to determine compliance with other relevant dimensional standards in addition to lot area, including lot depth and width. This approach would also provide a clear and objective application of the city code requiring what constitutes lot area. I think I just have, two more. I think I just mentioned this one. So just to be clear on what the applicant is saying, I think it's important to know the applicant properly relies on, this is from the applicant memo, Exhibit AQ. Applicant relies on lots 2 and 7 within the Cedar Creek Plaza to meet the minimum lot area requirements because both lots were part of the original area approved for the Cedar Creek Plaza development. And this is where, some interpretation on their end comes in around lot and lot area. And I just wanted to note that the definition does not include language referring to a site plan or a subdivision, which is how they are interpreting it here. And again, it would be a little concerning if we interpreted it this way, because we could have a large site plan application and a large subdivision, and then density would be able to be transferred throughout that large site plan and subdivision. And again, we don't think the code supports that. The second sort of point that I wanted to make on this statement is that the subdivision occurred after the site plan approval and created multiple lots under separate ownership. If this were still a single lot, hadn't been subdivided, I think the argument would be stronger. I don't know if we would agree with it still, but I think it would be a stronger argument. But they did a site plan approval and then they subdivided the lot and sold 5 out of 7 of them, and they like to retain the lot area of one of them. We just don't believe that is the way the code can be read in this case. And the other sort of issue that I'll raise with this approach and their argument is that the application does not include signatures from all of the other owners within the boundary of the original site plan approval. Although the application relies on these lots to meet parking, landscaping, and other standards, including compliance with commercial design review matrix. And so the argument kind of leads to another question of, do they need, if they are sort of leaning on the entire site plan and that area, do they need signatures and approval from, consent from the other owners to actually, lean on that argument? And then I did want to include just one previous example. A really important note here is that even though I'm using this example, you can't use this example to deny the application or approve it or anything else. It's just an example of how the city has seen the code in the past. And so I just want to be clear on that. You are making a decision on this application as it relates to the code. So it's really just for background, but you can't rely on this information to make a decision. But the example is the Sherwood Plaza apartments. It was in 2016. It did get approved by the Planning Commission, but it was never constructed. And so this is where the Ross is located and the post office is located. Langer Drive is here. Highway 99 is here. So again, 2016 approved but not constructed. So the entire site is 13.25 acres. And you can see this vacant portion of the lot behind the existing commercial development. This is 3.42 acres of vacant land. And in this decision, the city applied the HDR density standards under 010. We also applied the minimum lot area requirements. And importantly, we only gave credit for or applied those to the vacant portion and set the maximum number of units on this site plan through the vacant portion. And so the density in this case of 010 was more restrictive and led to an approval of 82 units at 3.42 acres of vacant land. And so this is really the only example that we have where housing came after the commercial development. We do have other developments where mixed use all went in at the same time. But this is the only example that we have a decision on the books where multifamily followed commercial development. And it is consistent with the way that the city is interpreting the code now, with the exception of density and applying density. And that is, if you notice, this was in 2016, just before the 2017 ORS around clear and objective standards. And so in light of that, staff does not believe we can apply density in 010 to this current proposal. But I just want to, for background note and for the record note that the staff recommendation for this evening and the way we've applied the code is consistent with the only example we have regarding this specific issue around multifamily and commercial zones. And now that I've talked a lot about that, I'll just talk about the site plan in some detail as well. So here is the site plan. The building is in yellow, central courtyard in green, and perimeter landscaping in green. The parking and loading areas are going to be here in gray. There is a proposed pet area here at this corner of the site. Planet Fitness would be here for reference. In terms of the building design, the front elevation is here. So this would be facing the interior of the commercial center, and the rear elevation here. So this would be facing the townhomes. In terms of parking, there's been a lot of communication on this application regarding parking. The applicant proposes to meet the minimum parking requirements by sharing parking with other lots in the Cedar Creek Plaza Center. The plaza contains 3 different tracks with different restrictions on parking based on the CC&Rs. So there's the Deacon tract, which is here, the Rembold tract, and the Providence tract. Regarding the multifamily proposal, there are 84 stalls designated for residential units, 13 stalls for guests, for a total of 97 stalls. They're proposing 92 stalls total on lot 2. So 5 of the stalls will need to be somewhere else on within the Cedar Creek Plaza Center, but not on lot 2. As I mentioned, there's 2 different sets of CC&Rs that apply to this project. I can answer questions on parking if you'd like, but the staff recommendation is that the parking requirements have been met. This is a table, a very detailed table that shows all of the different shows the different restrictions and how you get to meeting the minimum. But the conclusion is that there's based on the code and the restrictions in the private CC&Rs, is a surplus of 64 units. Staff has corrected that to be 63 units. And then for the staff recommendation, based on all the background that was just provided, staff recommends denial of LU 2021-009 and adoption of the findings of noncompliance. Sorry, maybe I'm not sure what happened there. out there. Can you guys still see the screen? Nope, went dark. Okay, I'll just wrap this up really quickly and then, well, do you want to check? See if we can get that. Yeah. I can speak to this. So staff recommends denial of LU 2021-009 and adoption of the findings of non-compliance for 3 different sections. Do we kick that maybe? Yeah. I see. Bingo. I won't repeat everything. Don't worry. All right. Staff recommendation. An adoption of the findings of non-compliance for the code related to 16.12030, 16.22020, and 16.90.020 D1. And these are all related to meeting the minimum lot area requirements. And in terms of your alternatives this evening, you can deny the application and adopt the findings of non-compliance in the staff report, deny the application and adopt additional or revised findings of non-compliance, or approve the application and adopt findings of compliance for the 3 code sections in the staff report identified as non-compliant. And I do want to just state that this is just a staff recommendation. This is, a decision that needs to be made by the Planning Commission with input from staff, and happy to answer all the questions that you have to get you to a decision this evening.
And timeline you were going to. Do you have that at the
Yeah,
beginning?
so timeline, thank you, Chair Simpson. We have 2 options tonight. If we get a request or the Planning Commission feels like they would like to leave the record open, we can do that. So what that would look like is we're here at the continued hearing on May 24th. We would need to go into what we call the 777, 7-day open record period, 7-day for rebuttal, 7-day final applicant argument, and then come back on the 14th for a decision. And that would set us up for if we received an appeal, a hearing before the City Council on August 2nd. If we do not get a request to leave the record open and Planning Commission does not feel like one is needed, you can issue a decision tonight, and that would leave plenty of time for a Planning Commission or a appeal to City Council.
And this is, since it's not the initial evidentiary hearing, we've already met the obligation for continuance because this has already been continued 3 times already.
Correct, 2 or 3 times, yep, or more, yep.
However, if I recall correctly, you didn't actually conduct the hearing the second time, right? So there's initial evidentiary hearing, you continued it and immediately continued it again without opening for testimony. So this is the continued hearing.
This is the continued hearing from the initial evidentiary hearing that was continued. So I just making sure we're not under the legal obligation of an initial evidentiary hearing to continue.
Right, this is just the continued hearing.
Perfect. All right. Any commissioners have any questions of staff before we open up for public testimony in the application? Okay, excellent.
Not to rehash the parking thing too much, but what was the basis by which you used other site or other lots within the development to support parking? Are there reciprocal parking agreements in place or something? Is that? Okay, yeah, speak to that. Please.
Yeah, so sorry, I kind of went over that, but glossed over that. But so there's 2 different sets of CC&Rs. One that's just the Deacon tract, and then another that's the entire commercial center. And so they have different restrictions. The most notable one is that the Deacon is at if there is parking that is required for residents, it has to be on that specific tract, either the Deacon tract, the Rimble tract, or the Providence tract. Right now, the only housing would be on the Deacon tract. And so we wanted to make sure that that tract alone met the requirements while leaning on all of the other tracks for non-residents. It's a little confusing, but the resident parking is met on the decontract, and then the guests and the customers and everybody else, they do get pushed over in terms of meeting the supply, and they're required to lean on the other tracks to meet the minimum code requirements. But they did a really detailed parking analysis to sort of pull out all of the restrictions on residents and I mean, there's a whole bunch of stuff, contractors, and say, all right, when we allocate all these to these specific track, here's what's left over. And here's what's required by the code, and what is left over exceeds what's required by the code. And so there's a lot of nuance to it, a lot of just restrictions in the CCNR, but we made sure that given all of those restrictions, that the minimum requirements in the code required by the code were still met.
Presuming residents only park on decontract.
Correct.
Is there a mechanism from the applicant to make sure that's the case? Guests don't park or guest park where they're supposed to and all that, or maybe that's not something we get into here because it's CCNR is based.
Right. So, sorry, I'm a terrible multitasker. Let me just log back in here. Here we go. So if we go back to this slide, so the decontract, Rembold tract, and Providence tract, to answer your question directly, the city would not enforce those CCNRs. However, we do have provisions in our code that say, you know, the private agreements need to support the findings, you know, and the approach to meeting the minimum code requirement. And so, for example, if the CCNR said, you know, residents cannot park anywhere on this in this entire shopping center, but they had housing in the shopping center, obviously that would be problematic. So we want to make sure there's no sort of fatal flaws like that. But the city would not be involved in enforcing private parking. If the private parking overflowed into the public street, then we, you know, that would be our problem likely, and we would, you know, we would have to enforce that if there were complaints. But there is likely going to be a provision in the CCNRs for management of parking, including enforcement.
So your role in the city is then to make sure that there is sufficient parking, like by contract existing, but the enforcement of all that gets worked out outside of this.
Correct.
Okay.
Yeah.
I have another question.
Please.
I don't want to hog your time.
No, go for it.
All right. I want to circle back really quick to 16.22.20. You mentioned this, and I just want to go a little bit further into this, where it says multifamily housing subject to dimensional requirements, high density. Okay, so high density when located in upper floors and rear of or otherwise clearly secondary to commercial buildings. Okay, I followed you on that, but as a footnote, commercial secondary to commercial buildings is defined. It's a defined footnote. So it's okay. So in case we're wondering, what does secondary to commercial buildings mean? It means this: residential portion of a mixed use development is considered secondary when traffic trips generated, dedicated parking spaces, signage, and road frontage of residential uses are all exceeded by that of the commercial component, and the commercial portion of the site is located primarily on the ground floor. There's no ground floor commercial component here.
Old code, new code. That's the new code.
I'm reading in the staff report, what's in the staff report. Footnote 2 on staff report page.
Oh, I see.
Packet page 27.
I see.
Commissioner Vance,
Yeah.
the key word there is otherwise. So it's when located on the upper floors, so that's one way to meet the requirement, or in the rear of. That's the second way to meet the requirement, or otherwise clearly secondary to.
So
There are three ways to meet that requirement. It either be on the upper floors or be in the
I'm on
rear of, or
packet
be,
page
or meet
27.
that more detailed footnote for otherwise clearly secondary.
Okay, so but then you'd be assuming that we're talking about the entire development here, because it's relying on being not just the actual 2 lots that we're talking about.
Yes. So yeah, Josh, what Josh explained is the same way the staff report reads this code in compliance with the code, that the residential portion of the development is behind the commercial buildings. And so we did take a look at this from an entire commercial center.
The whole commercial center standpoint,
Right,
rather than
correct.
just the two lots that were
Correct,
in play here.
right.
Okay.
And so this footnote 2, we can ignore it because they're not meeting it by being otherwise clearly secondary, which then they would need to meet this. They're meeting it by being in the rear of. You only need to check one of these 3 boxes, either upper floors, rear of, or clearly secondary. They're checking this box and then they're done.
And because those secondary buildings have retail primarily on the ground floor, footnote 2 works. But only if we're considering the whole development as part of what we're talking about, not just the lot.
Yeah, so
Okay.
if, for example, you had let's say the site was really, there's a situation where they wanted the residential portion of the building to be, say, at the front of the site and on the ground floor. So it wasn't on the upper floors, it also wasn't in the rear of. They're not checking either of those 2 boxes, then they would have to meet this requirement of, or otherwise clearly secondary. And then we would make sure that they complied with this entire footnote 2. But if the housing from an entire development and center standpoint is either on the upper floors or in the rear of, then they meet that requirement and they don't need to get into subsection 2.
Yeah, I understand. I think where I was going is you're looking at it as a whole development is how you're looking at this. And if we were just looking at it in terms of just the lot that we're talking about, or the 2 lots, there are no other commercial buildings there. This would be only one. You need commercial on the bottom floor. That's the way I read it. Okay. Okay. All right. Thank you for answering the question.
Yep.
And try to articulate the question concerning lot area. So I understand the lot area for lot 2. The utilization of lot area for lot 7, which is developed, but it's not developed with residential uses. Is the applicant asserting that they can use that lot area because it wasn't developed with residential uses? How is it left over to be used and sucked, brought over to lot 2? Or maybe that's a question for the applicant.
I think
That's not clear to me, is that how that's available, even if it could be used, how it's available to be used.
right. And I think that is where that is kind of the challenging question to answer, and where staff has said, based on our best read of the code, there really isn't
Right.
a opportunity to do that. And that's where we're saying, if we were to read the code and apply it in a clear and objective way, also consistent with our past interpretations, they would not be able to utilize that lot area for residential uses. And the issue is it's not specifically that it has been developed. I mean, it's really both. I mean, that is sort of an unanswered, but also the fact that they are not touching each other. And so again, like I was mentioning, how do you just apply lot area and send it over, but not anything else? And we might hear from the applicant a response to that, but in the application we have in front of us, they haven't clearly articulated sort of how to approach that, all of those other standards in a clear and objective way on this application and with others.
Eric, can you go to the second to the last slide on your presentation? The one before that. So I just wanted clarification, or just to see what sections of the code of noncompliance. Can you just briefly touch on what 030, 020, and 020 D1 relate to?
I can. So 16.12030 is going to be,
that was the one that we just reviewed with Commissioner Bance, correct?
So I'll start with, so that's going to be residential. That's going to be the residential use table. Sorry, that's going to be the residential development standard section. So when we say, when the retail commercial zone says meet the dimensional requirements of the HDR zone, when you go in section 16.12.030, and so they're not meeting that section because they're not meeting the minimum lot area requirements for HDR.
Based on that calculation that was in the presentation
Right.
previously, correct? Okay.
Right. 16.22.020 is the retail commercial use table. So we're saying that the use of multifamily in the retail commercial zone, they haven't demonstrated compliance with that because they haven't demonstrated compliance with the HDR standards. So it's separate but related, same issue. And then 16.90.020 that is our site planning approval criteria, which just says that any site plan approval has to meet all of the other sections of the code. And so they didn't meet that one either.
Okay. Great, thank you.
Sorry. Okay, so we are moving on to the applicant testimony, and I have two applicants signed up so far, Garrett Stevenson and Brad Kilby. If we'll have you move the microphone close and turn it on.
All that.
Start with your name and address for the record.
Brad Kilby. Address is 205 Southeast Spokane Street, Portland, Oregon 97202. I am a land use planner for Harper Huff Peterson Regelis, who is representing Deacon this evening. I have a presentation. Oh, somebody sign in. Perfect. This is awesome. Thank you. Commissioners, thank you for your time. I'm actually going to just kind of move through this very quickly because you've heard everything and read everything about this project, and you know our position on it. This is the project location. Commissioner Bantz, I appreciate your question because that is exactly what we are getting at. You're relying on the entire site for a lot of other things. This is a major modification to the site plan that was approved in 2017, not to just lots 2 and 7. It affects the entire property. So the lot 2 itself is 1.73 acres that we are proposing to develop with 67 multifamily units. We were originally at 84 and reduced that because at the last hearing, the owner of lot 3, which Deacon owned at the time that they submitted this application, opposed the application and said that he would not. And so rather than fight that battle, we just went back to the original or went back and used the area for lots 2 and 7, which are still, again, part of this development. Oops. This is the updated, actually, so it just not really anything different than you didn't see from Eric, and I just wanted to point out a few things. So we are required, because the code allows you to use shared parking, and shared parking says you take the largest use, which is in this case, the assisted living facility, and you have to provide 100% of the parking there. And then you go to the next larger use, which is our multifamily use, and you use 90% of the parking there. And then you go to 80, and I think it stops at 80. It doesn't go, but it's 80 beyond that. So you can reduce the parking minimums. So we were, if you did the, Eric did the calculations and I checked them. So we would have been required to provide 97 parking spaces if we were providing 100%, and that included the visitor parking of 15%. With the shared parking agreement, with the shared parking, we could go down to 88 parking spaces, and we're providing 90 on lot 2. So 90 on lot 2. And then in addition to all of that, we do have those CCNRs in place where Deacon was one of the original owners. along with Providence and Rimbold to share parking on these sites. And then when Deacon subdivided the lot in 2017, they recorded another separate set of CCNRs, which all the owners, every one of those owners are subject to those CCNRs. When they bought the property, they signed on to it. They understand that they're part of that. And so they can't question those CCNRs. They can change the CCNRs once they're the declarants, but they're not the declarants at this point. And they are negotiating with Deacon to get to a point where they could put together a parking management plan. Let's talk real quick about traffic. These are the things that come to my mind. So with the reduction to 67 units from 84, we further reduced the parking impacts from this development. When the when the hotel was considered, we would have had 316 additional daily trips. And now reducing it to 67 units, we reduced the number of trips that would go into and out of that site daily by 316. So the proposal is Deacon Development is the owner and the applicant. We're proposing the 67 units broken down into 6 studio apartments, 56 one-bedroom units, and 5 two-bedroom units. And the mix of units is kind of key in some of my testimony here in a few minutes. The amenities that would be include an outdoor pet area, central courtyard inside the building. The building didn't change. Rooftop deck, as well as a covered patios on the 1st and 3rd floors, pet wash station, covered parking, and bike storage rooms. This is the overall site plan for what was approved under the original Cedar Creek Plaza. And what's highlighted up there is our site plan showing the parking and the building and lot 2. So I think I don't want to belabor this point. I think staff has found that in every case we've met the code, with the exception of what we disagree with them on how that isn't a density transfer. We're not asking to transfer density from this site, which was approved as one consolidated development, over to, say, where the Albertsons used to be or somewhere or in the center. We're not doing that. And you probably couldn't do that because the major modification would apply to this site plan. It doesn't apply to this site plan and any other piece of property that Deacon owns throughout the city. So from that point, I think that's where kind of our disagreement comes in. The 2019 housing needs analysis conducted by Eco Northwest shows that there is a demonstrated need for multifamily housing in the city of Sherwood. And now I'm going to jump on my quick soapbox because it's not really that quick. I'm always reminded by my time here and what Commissioner Simpson always used to tell me is you make the right things easy to do. And this is the right thing. And I'll tell you why it's right. Because needed housing is not only a legislation from the state, it's a requirement because you have communities that either deliberately or undeliberately hold up the succession of multifamily housing because of preconceived notions or stereotypes surrounding that housing. Multifamily housing supports residents of all ages. It supports your kids when they get out of high school. It provides an apartment that they can rent, get away from the house, live in while they're maybe working their first job or going to college. And secondly, it supports like your grandparents or somebody when they're time to downsize and they no longer want to be in a 3,000 square foot home on a 10,000 square foot lot in Woodhaven. They're going to look to and want to stay close to their kids and their grandkids. They're going to look for opportunities and other alternative housing types. It could be a townhome, it could be a condo, and it could be an apartment, but you want to provide the mix of housing types throughout your community. And just of note, to my knowledge, Sherwood has not approved any multifamily housing within the last 5 years. It's a needed housing type and you should consider it. And I just want to raise one last point. In our last hearing to Commissioner Kai mentioned that if we had proposed this in 2017, it probably would have been approved. And my question to you is, now we've placed these lines on a map that show these lots, they're delineated, but the owners, all 3 owners of the original development, nobody protested it. from either one of those original three owners. It's only people that have moved in that said, no, we don't want this. Why is it different now that you couldn't look at the entire site? And to your point, Commissioner Montalvo, it's not the highest and best use. So like you pass codes and regulations that place dimensional standards on an entire lot. So maybe commercial and industrial are probably the best way to use this, but on those, you might have somebody that built a building that's just a single story building 10 years ago, but you wouldn't tell them that they couldn't come back in and redevelop that site and build to the maximum height and the dimensions that would be allowed under the code today. You just wouldn't do that because that slows down and ultimately can kill your city. And cities that aren't growing are essentially decline and ultimately die. So think systemically as planning commissioners, think about the bigger picture and be very conscious about your decisions. And with that, I just wanted to really quickly let you know that we have a representative here tonight from Deacon Development, who's the owner. Garrett Stevenson is our land use attorney, who's here with us from Schwabe, Williamson Wyatt. And we have Wayne Kittleson, who is the traffic engineer and also he didn't perform the traffic engineering on this property, but he did do the parking study that's in your packet. And with that, I think I want to just let you know that we respectfully request that you approve the requested major modification. Thank you.
Good evening, Chair Simpson, members of the Planning Commission. My name is Garrett Stevenson, attorney for the applicant. I'm going to speak very, very briefly because what I'd like to do is reserve most of my time for rebuttal. I mean, you've heard a lot of some of the code arguments and so forth, that those are explained in our letter and what our position is. But before I go ahead and reserve the rest of my time, one housekeeping item, and it's a question from Commissioner Montalvo. Your question, Commissioner, as I understood it, was how can you use square footage from a lot that's already developed to justify additional development of multifamily housing? And I think the easiest way to answer that is the fact code, certainly at the time that this application was filed, would have allowed a building with retail on the ground floor and residential on the top floor. So I think that's the easiest answer there. But the thing I want to leave you with as you go on to listen to the rest of the testimony, and then I'll circle back to it in a bit, is that this is not a situation, I think, where the applicant has been wishy-washy or inconsistent. All the arguments that we've raised that are summarized in my letter from I think I submitted it yesterday, all of those have been in the record since I think as early as March, and even earlier than that. So, but the reason why I raise that is that this stuff's complicated. And certainly I would think that if it were obvious to staff, they would have informed us of their interpretation before they issued their staff report, which is not necessary to throw them under the bus. But the point is that we wrestle with these things because these codes are not always entirely obvious about how you deal with a unique situation. They're designed for typically greenfield development where you come in, and when you're doing infill, it's always hard. It's always hard to work around codes that were not designed necessarily for infill development. And that's really what we're wrestling with here. So what you've got in my letter, which I won't summarize right now, is really three different theories. And we lawyers like to make alternative arguments because for two reasons. Number one, we want to make sure that we're hitting all of our major cues. But the other reason is that, as I stated earlier, if reasonable minds can differ, this is the situation we have. And I think reasonable minds can differ. And so what you've got is three alternative ways to look at this. What the applicant did is chose a practical method, which was to take what staff was telling us, and what staff was telling us is, we are not going to support you using this if you include lot 3 in that, so you got to drop your density. And that's what we did. Okay. So working with staff on a practical level doesn't mean that that we're waiving arguments or that we're being wishy-washy. But I think that there's probably the best way, if I was in your situation, probably the easiest way to look at this is that staff has said, you know, effectively in their staff report, if these lots were touching or if they were part of a unified ownership, then this would not be a problem. And I just want to be clear that lots 2 and lot 7, those were never touching. And once that subdivision was approved, they were never touching, but they were part of a unified ownership, and that was known as the Deacon Tract. And the Deacon Tract was called, I think from what I can see in the record, it was called that from day one. It was part of the broader, you know, mixed use retail center out there. And it manifested itself in the CC&Rs. And I went I went back and I suppose I'm looking at this with fresh eyes because I'm the second lawyer from the applicant's team you're seeing. But I went back and I read the subdivision approval. What the subdivision approval says is that, hey, this is all one big lot. And what we're doing is we're creating new lot lines so that we can have lot lines for each little building. I think that's fine. That's really, really typical when you're doing shopping center type development. And so I don't think that there was ever an intent to end up in a situation where we're literally carving pieces out of the shopping center and the mixed use portion of it. I think that the narrative through the record has been entirely consistent. This is one piece. Certainly, I don't think we would be here if we owned necessarily, you know, enough lots to bridge the gap between lot 2 and lot 7. But I think that the easiest way to look at this is that the parent parcel that was originally approved for all of this back in 2017 included both of these lots that we're talking about now. And I think from that level, you don't even necessarily need to get to the definition of lot, but I've got an answer for you there as well. I'm going to save the rest of that for rebuttal. But if you have any questions now, I'm happy to answer them.
Excellent. Any questions of the applicant? Go ahead.
I do have one. For Mr. Kilby, do you have a response to the issue that staff raised regarding if lot 2 and lot 7 were allowed to be used together, the issue they raised of lot 2 and the road easement associated with lot 2, and how when you take out that square footage from the road easement, even the combination of the square footage falls below the requirement?
I'm not aware of it. I didn't see it until tonight. So that's the first time I'd have to take a closer look at it because I wasn't aware of that. And just want to clarify one point. We actually decided to reduce the density, not based on direction from staff. It was, you know, what we heard in the last hearing about that. And just one last thing about to answer that kind of go to that question. Let's just say every one of these people didn't have a problem with what we were doing, and they said, "Oh, let's put a multifamily use out there. We see value in it, bringing people to our business and things like that. Let's do it." Theoretically, they could have jumped onto this application. We could have increased the densities, you know, to meet the density that would be allowed within that center, right? As long as you meet the other standards. And the one last thing I would just part with is about the question about whether or not we're meeting the dimensional standards for lot 7. I'm not really sure that those were met through the land division. You couldn't divide the land unless you were meeting those dimensional standards. So again, these are just imaginary lines on a piece of paper that signify ownership, but it was all developed as a single lot of record. Thank you.
All right, any other questions for the applicant before we call for public testimony? All right, looks like 15 minutes, 2 seconds. All right. All right, I have 3 testimony cards in front of me. First is Christopher Kovac. And just for the record, Christopher Kovac is representing himself and 3 other people, Harold Cox, Bob Barman, and Richard Jaffe. And so the time allotment has been adjusted so that he will be taking the 4 minutes from each of the other people that he's standing in for.
Correct. 16 minutes total.
Those 3 other people have deferred their time to him, correct?
That's correct.
Okay, so they have the time up on the clock for you.
Perfect. Thank you, Chair Simpson. For the record, Chris Kobeck, my address. We just moved Saturday, so I'm gonna try to get this right. I think we're at 1125 Northwest Cooch now. Portland, same zip code 97209. And we're suite, I think we're suite 550. I'm gonna talk about 3 issues. I submitted a number of letters. The last one was last Friday. And I provided a copy to Schwabe Williamson when I sent it. The first issue has 2 components though. And the first question is, does the lot area apply? Because there's an argument that I read anyway, where the applicant is saying it doesn't even apply. We don't have to apply with any lot area. And they get there by saying, well, we only have to meet dimensional standards, and somehow lot area is not a dimensional standard. And our point on that is there's no way to read the text of the code to reach that conclusion, because when you look in your definitions, lot width is a dimensional standard. I think the applicant agreed with that. And they said lot depth is a dimensional standard. And those in your code are horizontal measurement. The depth is a horizontal measurement from the front to the back, and then the lot width is a horizontal measurement of the 2 from side to side. And how it occurred to me is just intuitively, if lot area is the product of 2 dimensional standards, you take the depth and the width to get that lot area. I don't think there's any way textually you could read the code to say that lot area is not a dimensional standard. And where this goes is we agree 100% with staff that when you look at how the code reads, multifamily is allowed in this zone subject to all dimensional standards for the high density residential zone. And so lot area is one of those standards, and it has to be deemed a dimensional standard if the width and the depth are also dimensional standards. So just from the textual standpoint, we believe that applies. And then I wrote a note down when staff was talking, they said, well, we applied that and we decided we couldn't also apply density. If you accept the applicant's argument, there's no limit. There's no, they don't have to apply with lot standard requirements, and they don't have to comply with any density standards. So in this one zone, this one application where you're proposing multifamily in a RC zone, there would be no limit. It would be as just you apply, I guess, the setbacks and the height restriction, you can put as much as you wanted. And that, we don't believe that's consistent with the purpose of the code and all of these standards, which are designed to make sure that the parcels that are being developed at the appropriate intensity. And so that's another kind of one of those where you interpret statutes. I think the law says if you're interpreting statute, you should interpret them to avoid an unreasonable result. And we think that would be an unreasonable result. The second sub part of that argument is, so if it's a dimensional standard and it applies, and we think it does, because although they argue it doesn't, the applicant in their application, as staff noted, clearly rely on lot 7. So they rely on, to get to their units, they don't say, well, it's not a dimensional standard, we don't need to worry about lot 7. They clearly say, we do need lot 7. And on that point, I'm going to lean a little bit on a letter that David Peterson from Tonkin Torp submitted on behalf of the owner of lot 3. If this is, you can call it whatever you want, but it is a density transfer ploy. That's what they're trying to do. They're taking entitlement rights, residential entitlement rights, to transfer and add density to lot 2. And our point is, there's a way to, it's not in your code. The code doesn't allow that anywhere, any text. There's no provision that says you as an applicant can take entitlements from a lot, a discontiguous lot, and transfer them over. And there's a process that the city has when you do that.
there's a planning commission recommendation, and then there's a city council meeting, and they decide we're going to change our code to allow this. And when you do that, in most cases that I've seen, if you're going to allow density to be transferred, there's other things that go with it, like you have to agree to restrictions. Because you're taking development rights from one parcel and you're putting them on another. And I think Mr. Peterson made this point really well, is when Lot 7 was developed as a commercial use, those impacts associated with that development were accounted for. And now the applicant wants to take some entitlement that it didn't use. It had the right to do either. It didn't use the residential component there, and it wants to take that component and all those impacts, move it somewhere else just because it's in the same site, and expand the impacts that were never contemplated when the original development was approved. So we agree that with Mr. Peterson that would be another, I think, unintended consequence of going along with this disguised density transfer provision. We agree with what staff said also. If you're going to take lot coverage or lot area from from the code and say you can use that to transfer, and how do you apply the other development standards? How do you apply a setback if you're using as the development site two disconnected pieces of property? What's going to be the front lot line? I think staff made, and the city attorney apparently reviewed it, made very good observations about the difficulties this would pose for the application of the code going forward. So that's enough on that issue. I want to talk about parking, unless you have questions on the first one. Parking is the one area we still disagree with staff on how staff applied parking. We read 1694-010 to say this: to rely on any of the shared parking provisions, including this reduction in the number of required parking, you have to be two components. One, you have to show that you're in a development, either a mixed use or another development where there are multiple uses and there's not an overlap at the peak hour. And then you also have to show that you have a clear right to use the other parcel for parking. And there are two sets of CC&Rs, we agree. The 2017 applies to three big parcels, the Deacon, the Ackerley, and the Remble parcel. That one clearly does not allow residential parking on the Ackerley or Remble or the Providence. It doesn't. And nobody disputes that residential parking is allowed there. The way we think the code has to read and apply is though that unless you can show a clear legal right to use it for residential parking, the use you're proposing, you don't even get to go to the reduction in the shared parking. You have to meet 100%. You can't say, we're going to say Ackerley is the #1 primary use because it's on a track that you have not established that you have the right to use for residential parking. The 2019 CC&Rs clearly allow shared parking on one track, the Deacon track, and we agree with that. And so what we believe is they have to show that they have the required parking based on the primary use on that track, because that's the only track they clearly have the right for residential parking. And from there, if they have 97, they haven't explained to you how they meet it with 97. They have 90 spots that they propose on lot 2, leaves a spillover. But more important, even if you read, I think if you read their traffic analysis, the January one agreed that when you're looking at shared parking on the Deacon tract, the retail center, you have to look at all of the parking on that tract, because they have the right to share our parking, my client's parking, but we have the right to share their parking. So you can't just say we can put 90 or 92 on our space. They have to account for all of the parking. And that's, I think, what Kittleson did. And they came up with this conclusion that if you look at just the Deacon tract, and there was, when they did it in January, they needed 110. They used the reduction from 122 to get to 110. They said, if you rely on the 90% back then for 84, we're 39 spaces short on the Deacon tract. We're going to make up for 39 on Providence. I think they agreed that Ackerley's already 100% used. They have 98, they need 98.
But their analysis was, we can make up those 39 on the Providence track. And the only thing that's changed is the math. I redid the math tonight when I was waiting. And I think on parking, if you assume that they need 97, because it's the primary use on the parcel at which they have a right to share parking, they're 26 short. 26 spaces short. So they'd still have to say, well, we're going to get those 26 spaces on Providence. The problem with that is, and I think Commissioner Vance asked questions about this, is that requires you to assume that no residential parking is going to go there. They want you to assume that all of the residential parking is going to stay on lot 2 or thereabouts, and only guests and invitees are going to go to the Providence parcel. Because under the 2019, the way they interpret it, and I think you can interpret it this way, guests and invitees from departments could park there legally. That's a big reach if you look at how it's going to operate, because it's not going to happen. There's no enforcement mechanism. And the problem this posed for my clients is the parking that the apartments are going to take, it's different parking. They're not coming and going. They're not using the businesses. Their cars are going to be there. So if they park in front of the businesses in the retail, customers can't park there. And if they leave their cars there, or if their guests, because there's not enforcement, leave their cars there, that's hurting the retail. Now, there was an argument that Mr. Kilby made that we didn't protest. My clients didn't protest. Well, there's a good reason for that. When my clients bought their property, the literature that we gave you in December in our submission showed they were representing to everybody that it was going to be a hotel. Now, a hotel is much more compatible with the retail uses. It has a lot less parking requirement. Now, Mr. Kilby focused on the hotel and how it reduced trips. My clients don't care about the number of trips and the traffic index. They care about the parking. And the apartments require a lot, or the hotel required a lot less parking. My clients, when they bought, they believed it was going to be a hotel, it was going to be compatible, and it was going to have less parking requirements. So they didn't protest. There's been a dramatic change, and the parking requirements have gone up. And what I've just illustrated is there's going to be a shortfall on our tract, and it's going to impact my client's business. That allows me to segue into the third point, which nobody's really talked about. We raised it in writing, and I testified about it briefly at the first hearing, is when the original when the original site plan was approved that we're modifying, there were clear representations that this was going to be a hotel. And I cited the case law. I'm not going to go into it in detail tonight, but there is law to support the notion that when an applicant makes specific enough representations about a use, that is a condition, a development condition they have to meet. And here they represented clearly in writing and verbally, it was going to be a hotel. Now, the point I made is if you agree, reading that material, that there was a representation that rose to the level of a development condition, the application needs to modify to remove that condition. And they haven't asked you for that. This application assumes lot 2 is vacant. It's a blank slate. But if that's a development condition, we believe their application has to first address why should the commission allow them to remove that condition, that it be a hotel, and turn it into something else. We believe that's important because then there would be the analysis that we think is important, which is how is that change going to affect the overall operation of the development? How is it going to affect the shared parking? Everything that was done up to the point where they changed to the apartment was based upon that being a hotel. And so that would change, in our view, that would change dramatically how some of the original analysis of this site that they want to use, this entire site, goes through the process. So I don't want to, we didn't dwell on that as much as the other two issues, but it is an important issue we raised, and we believe it's something that the commission should clearly evaluate as one of the issues before you can come to the conclusion this is approvable. So in summary, we think from the lot average or the lot area standard, clearly do not comply. It's a dimensional standard. We believe the parking, there's a deficit, and they haven't shown a clear right to reduce their parking based on the Providence parcel because it isn't available for the use they're proposing. And then 3, there's a condition of development that should be imposed, and they have to show you why should they be allowed to change that condition now and go from a hotel to an apartment. So unless there are questions, I'll spare you the rest of the minute 19.
Questions of the opponent?
Thank you.
Thank you very much. All right. Our next blue card is also a joint blue card, I believe. Mark and Julia Light. I believe Mark is representing Julia for a total of 8 minutes.
Guys, I'm fairly unique at this. I'm learning as we go along. So, you know, you'll have to forgive me a little bit, I think.
Well, if you would just start with your name and address for the record, that'll get the ball rolling there.
Park Light, address is 17117 Southwest Robinwood Place, Sherwood. Zip code is 97140. I think I'm fairly unique probably in this because I actually live in the townhomes right next to where this is going to be. So we have opposed this right from the very beginning. Since day one, since the very first public hearing. Why? Because of that fact. We live in the neighborhood and we know the negative impact that this is going to have. We originally raised concerns with the carbon footprint, the noise, the extra trash, the increase in traffic, the inadequate parking, as everybody else has mentioned. We believe severe parking conflicts are going to arise. And we also believe, because we don't believe that the traffic is going to be reduced in any way, shape or form by going to residential as against a hotel. And that is the intersection of the Plaza, Edie Road and Borchers Drive with just one egress from it. We know that it already gets very congested. It'll only get congested when you put more than 100 people more in that plaza. All concerns we believe to be valid and common sense objections, but we believe that they don't seem to carry much weight within this process. I don't know why, but we don't. So we've got 3 points, and I think some of these have already been raised, code related. Point 1, we believe from your own planning density calculations, lot 2 can only support 46 units. We also believe the applicant is using lot 7 as a density transfer to allow those more than 46 units. And from my understanding, density transfer is not allowed, and therefore this application can't go forward. It can't go forward as 67 units. Point 2 is related to chapter 16.22, commercial land use district. I guess here I respectfully disagree with staff. I think that the commercial zone district table 1622.022 should apply. It is the current standard that you should be going by. That development, which was changed in September of last year, says that there must be commercial on the entire ground floor. This doesn't have any. So therefore, again, it should not go forward. Point 3, chapter 1612, which I think has been mentioned, 0.030, states, as we've said, multifamily housing subject to dimensional requirements of HDR zone when located on upper floors in the rear or otherwise clearly secondary. Well, I think the upper floor element for me has been clarified in September. The development use in the entire area is developing in the entire area of lot 2. There, for me, I look at that and say, it can't all be within that rear of a commercial building. It extends past the end of lot 3, which is Mud Bay, and therefore it will be in front of the opticians, Hops and Drops and IHOP, not in the rear. It'll be in front. And lastly, to the same code, in my opinion, with 67 units, it will become the primary and not clearly the secondary to commercial buildings, you know, as that code requires. So in conclusion, we provided numerous of what we believe to be common sense reasons why this development will be a negative impact on the plaza, the neighborhood and Sherwood. And in addition, there are 3 planning codes failures which we think should not pass. So again, we've stated from day one, we believe this is a wrong development in the wrong place and should be denied. That's from me. Anybody got any questions? I mean, I don't know whether I can answer any, but you're more than welcome to answer them.
Any questions of the opponent? All right, thank you very much. Certainly.
Want to say the concerns or issues that we don't address, it's not that they're not important, it's just or not relevant, but it's just that we purely and solely judge based on the code. And so the other points that you further articulated were code related, and really those are the only things that we can judge upon and whatnot. So I just wanted to make clear that those other concerns, it's just if they're not related to the code, we can't speak to them. So
I get it.
Yeah.
But as a layman, as a person that lives by it, those things are important.
Absolutely.
And to us, as people that are going to live right next door to this and affect our day-to-day living and day-to-day use of that plaza. That's, you know, and I get it that you can't necessarily take account of that. But maybe it should play part of what you guys do. And that's as a layman, just sort of speaking from the heart, I guess.
Thank you.
All right.
We do have one, I think a minimum of one party on Zoom who would like to provide testimony in opposition.
Oh, my apologies. We
No.
should have started with that.
No problem. So it'd be Mr. Peterson and.
Can you hear me all right? Hello? Can you hear me? Hello? Can you hear me there? Hello?
Okay.
No one else in opposition though, that's here in person?
No, that concludes the in-person testimony. And we will pause for a moment while we get, look like we have a Zoom connection here. No, that concludes the in-person testimony. Pause for a moment. Look like we have, oh, that is on echo, a delay.
All right, I'm off of mute. Can you hear me now?
Yes, we can.
Is
Go
it
ahead, provide your testimony.
sure? Is it acceptable or is it echoing? It's okay. Okay, great. Well, my name is David Peterson. My address is 888 Southwest Fifth Avenue, Suite 1600, Portland, Oregon, 97219. I represent the owner of Lot 3, Lake Bowman LLC, and it's probably in the end better that you had me go last because I won't subject you to testimony from Zoom for very long because we pretty much agree with everything that Mr. Kobach said on behalf of my client. And I don't want to belabor the points that he made. I will touch on just a few items, though. With respect to the staff's report, we support the staff's interpretation of the code. We find it to be both fair and reasonable, as well as clear and objective, probably the most clear and objective interpretation you could give it. If ultimately adopted by the city council, I have no doubt it would be entitled to deference as a reasonable interpretation of the code. The staff report doesn't expressly address the issue, but I think you can read from the analysis of the provisions related to the density requirements and the dimensional standards that there is no transfer of development rights scheme in Sherwood. That's certainly clear and obvious. And as Mr. Kobach said, there's really no way around it. What they're proposing is a transferable development rights scheme that the city does not have. And as he also credited me for, I would like to touch briefly on the issue of impacts. The idea that you can effectively take residential development that you might have been able to build on lot 7 and move it over to lot 2 while still having the same commercial development on lot 2 that you might not have had there, had it been on lot 7, that might not have been there had you had residential development. It just throws all of the impact mitigation out of whack, or at least it has the potential to throw all the impact mitigation out of whack from your site plan. So that's just a potential casualty of this scheme that has not been addressed by the applicant, to my knowledge. On the issue of parking, I know there's a lot of back and forth about how many spaces this project requires, and it depends in part on whether you're applying the shared parking reductions or not. I agree, my client agrees with Mr. Kobach and his clients that the shared parking scheme is not applicable here because lot 2 is not eligible to park on either of the other tracks, at least not for residential use. I think there's some inconsistency in the various documents about how many spaces are required. The staff report says 97. The applicant says 88. If you don't apply the shared parking scheme, the number is higher. The parking study from February 9th says 92, but under any scenario, there's a deficit in the number of parking spaces available on the deacon tract. And so that necessitates an obligation for parkers who are eligible to do so to park over on the Providence tract where the surplus exists in order for there to be enough parking on the deacon tract for the residents. And we've got no evidence in the record that suggests how or this is going to happen. There's not even any proposal for some kind of mitigation to encourage this to happen. Nothing about signs or arrows or anything like that. So without any evidence that enough parkers who are eligible to do so are going to switch to the other tract, there's no evidence on which the commission can conclude that there's sufficient parking on the deacon tract to serve the residential project, no matter how many spaces under the various different calculations it's ultimately determined are required.
Your 4 minutes are up, so could you wrap it up in a sentence or two?
Okay, so I just, yes. The last thing I wanted to say is this idea that they can somehow modify the entire land use approval for essentially 8 different owners because the owner of 2 of the parcels wants to do so. I mean, that's frankly absurd. They've got to get the consent of the other owners if they want to modify a land use approval that applies to their property. That's all I have.
All right, thank you very much. We have one other person on the Zoom. Are they testifying or observing? Oh, okay. Thank you. This hybrid situation throws a new wrench in something we barely got used to. So, all right. So I think all the opponents have testified and we had no proponents. So the applicant's rebuttal time is the remainder of their 30 minutes. And so you have your 15 minutes, 2 seconds. Do we need to take a break before we call for the rebuttal? Good to go. Okay. All right, we are all good to go. So 15 minutes, 2 seconds on your rebuttal.
Chair Simpson, if I could actually ask for a bio break, that would be great.
Okay,
If it's okay with you, and I will give you those 2 seconds to ask for that break.
all
So if we
right.
could reconvene in 5 minutes. I think that would make our group a little more comfortable.
Okay, that would be great. We will recess for 5 minutes.
Thank you.
He ran away and had a sight out. You ready to put your gun? All right.
Sure. Yep.
Your water wasn't good enough. That's a good one.
Do you want a nutter butter as well?
I don't eat during. I'm taking chocolate. Like at a restaurant. Thank you.
Yep.
Back. Back. I threw myself on it. We ready again? Staff, are you ready? All right, we are back. Now he has 15 seconds, or 15 minutes, sorry.
Chair
I
Simpson,
didn't do it.
15 seconds, so that would be a whirlwind for us all, I think.
It would. Be.
Once again, Garrett Stevenson, attorney for the applicant. So I've got kind of two sections here. I've got kind of a practical section about planning, and then I wanted to address some of the code issues we've heard tonight. But I think that there's a lot that's, before we lose sight of it, I think there's a lot here that staff and the applicant agree on. In fact, it's about 99% of the application when you look at the actual development standards. And I don't want the Planning Commission to lose sight of that, and I don't want to lose sight of that. We think that the staff report is 99% right. What we have to talk about and have been talking about tonight is just those areas where we're in disagreement with staff. And I told this to both staff and the city attorney when we talked to them about this before the hearing, is that you know, I don't fault anybody for looking at this and scratching their heads a bit, as I mentioned before. And I think that, you know, really there's three ways that we can look at this, and I sort of teed this up earlier. The first way is you can look at this from a sort of hard-nosed legal standpoint about, you know, what does this look like under the needed housing rules, and what does this look like under the rules of statutory interpretation? And what those rules say is that you can't add words to code provisions that aren't there, and you have to look at the language of the code, not necessarily what the intent was. And the way we do that as lawyers is we say that the language of the code is the best indicator of the intent. And when you look at it strictly that way, you can make an argument that I think is reasonable, that the density, and I use the shorthand density, but the minimum lot area standards of that HDR zone are not applicable. And that's just from a strictly textual analysis where you say, all right, look at the development standards, and then you go and you look at that code and you say, well, or excuse me, look at the dimensional standards. And so when you go to that code, and I think it's 16.12.030, we look at that and we see dimensional standards and we see area standards. And one of the things that LUBA is very, very strong on is that if you have multiple categories and the city takes the time and effort to define things in different categories, then we give effect to that. I'm not necessarily convinced by Mr. Kobach's argument that two-dimensional standards automatically make an area standard, because that doesn't agree with the geometry of anything except a rectangle. But I guess my point is that we don't really need to get there. We make that argument because I think that it's correct under a certain perspective. Certainly, you can have lawyers that would argue about it. But I think there's a more practical way to look at the situation. And I actually think that staff stated it very, very clearly and correctly in one of its prior staff reports. And I'm just going to quote it. It says, while the city's development code does not have a process for transferring residential lot area entitlements, staff supports the approach because the proposed building is within the same commercial center / subdivision as the other lots being borrowed from. And I think that's a shorthand way of saying that, as I mentioned earlier, what you have. And I think the fact that this is a modification of a previously approved application is important. What you have is you have this center that was approved with a number of mixed commercial and medical office type uses, as well as some senior care. And what was left over from that was the Deacon Tract. They established the shopping center there. They executed the CCNRs that the other attorneys here have argued about tonight. And then they went in and they divided it up so that each building could live on its own lot. This is not a question of whether or not we have control of the lots. The fact of the matter is we have control of a lot area that is sufficient to justify the density we're proposing. It's from the original shopping center that was approved. That's why it's a modification and not a new application. I think that's probably the most practical way to look at it. The third way to look at it, and I detail this in the letter, is, I think that this works for us too, but I wanted to go through it. And I think this is kind of where staff landed on. The definition of lot says a single lot of record, and this is in SZCDC 16.10.20, says a lot is a parcel of land of at least sufficient size to meet the minimum zoning requirements for this code, and with frontage on a public street or easement approved by the city. A lot may be a single lot of record, or a combination of complete lots of record, or a complete lots of record and portions of other lots of record. So what you have is two lots that were originally part of a single parent lot that was used to approve the plaza itself, were later subdivided, but they're still owned by the original developer. They're still owned by Deacon. It's not a question of whether we need authorization to build on our own lot. That's not it at all. The definition of lot does not include a requirement that the lots have to actually touch that you're using. And when we look at the needed housing statute, which was raised by my predecessor in this file and reiterated by myself in our May 23rd letter, it says that basically when you're talking about housing, this is not necessarily the case if we're talking about commercial uses, but when you're talking about the development of housing, you have to apply the code in a way that is clear and objective. And to the extent that this planning commission ultimately decides that the definition of that word is dispositive, I think it's really easy to get to where we're looking at it, which is that there is no requirement necessarily in there that the lots are contiguous. Now, there's been a bunch of arguments about, okay, well, where does this leave the code? And I understand that. And my background before becoming a lawyer was as a land use planner, and I even started out working on the municipal side. And so I get that. Here's why I don't think you need to worry about it. We're not talking about moving density across the street. We're not talking about moving it across the city. We're talking about something that would have been approved, but for the fact that staff has decided that the two lots need to be contiguous. All of the various evils that we're talking about, how does the code work? Those are not necessarily issues for this application. And I don't think they're issues for another one. In terms of the density transfer, I agree. The density transfer code has not been adopted, as near as I can tell, by this city. We don't need a density transfer code to do what we're talking about today. As far as the lot area, there's no debate that that the building on lot 2 provides the setbacks that are required in the zone. And I think a good point here too is that the lot areas and the lot dimensions are already established. So, you know, I don't think that in this quasi judicial setting, you even need to get to the point where you're thinking about all the various evils about what could happen here, because this is a very site-specific application. It's a site-specific application that's based on a prior application and that relies on modifying that application. And I also think that the question about whether or not, you know, if we're right, somehow that breaks the code, I don't think that's the right question, because the code's been updated to make it clear that from, and I believe this is so, but Mr. Rutledge can correct me if I'm wrong, but the code has been updated to very clearly call out the density standards of the HDR zone, where that link was not nearly as clear as it was before. So, you know, the slippery slope arguments are always there, but none of those issues are presented to this planning commission by this application. So, I mean, that's really kind of the general, sort of the general thrust of, you know, where I look at this issue. You know, there's been a lot said about, well, this is a density transfer. Again, it's not a density transfer. All the density that we need was originally established with the original approval. You know, the CC&Rs are what they are. We believe staff got that right. Certainly, if the opponents believe that the CC&Rs are being violated, there are private mechanisms to enforce those CC&Rs. But we think that the parking analysis here, which we've offered, which staff has looked at and has reviewed, is correct. I don't want to get too deep into that. But I think what you are left with is choice. I mean, you've got two different legal analyses in front of you. We think ours is the correct one. That doesn't mean we think everybody else is stupid, because as you can tell, you know, staff went one way and went the other way. You've got a bunch of other lawyers here all arguing about what it may mean. But at the end of the day, I think that what we've provided this planning commission with is a very defensible legal analysis about how we get there for this development. Again, our desire is not to somehow bootleg a broader density transfer concept in the code. And as I said, I think the code updates would foreclose that anyway. What our desire is to develop this property with a product type that the city has said it needs, which is multifamily housing. It's a great use. It's adjacent to existing multifamily. And what the city's own housing needs analysis has said is that we need to rely on some of these commercial zones to establish more high density housing in the future. So, you know, absolutely, I think we've got the correct argument here. But the point is that this planning commission can approve this if it wants to. Certainly staff felt that way at one point. We still feel that way. We've got three legal theories that I think get you there. And we would encourage you to approve the application on that basis. So with that, I'm happy to answer any specific questions you may have. And I apologize, I tried to track any of the questions that you asked. I know I caught one from you, Commissioner Montalvo, but I'm happy to answer any questions or any queries about, you know, how the code might work, if you have any, before we conclude tonight.
I just on the record, it's in your letter, but you do, if there is not a denial or upon appeal or however it works, the conditions of approval as written by staff were all otherwise accepted. As written in your letter. Is that?
Yeah. You know, again, I think staff got it 99.9% right. One clarification I wanted to make that I've forgotten about is the issue of whether or not there's an easement over this property. I spoke with my client, and as far as we're concerned, there is no easement that would somehow net out lot 7 to be smaller than it currently is. That was a novel issue for us, but I wish I had a graphic I could show you. I don't.
I think it
But
was lot 2.
yeah, I'm sorry. Yeah, lot 2. From what my client tells me that there is no easement that would normally be netted out of there. So, assuming that's correct, I think we're fine there. As far as the density calculation is concerned, assuming that you agree with our analysis here tonight.
Okay, I just doing housekeeping on the part of the other conditions of approval were accepted by applicant. If it's not, if we go the other way. Okay. Do we have any other questions for the applicant and or staff that may be appropriate while the applicant is at the microphone?
I had one more question. So if in your proposal, you have the sufficient lot area, if you combined lot 7 and lot 2, if we were to support that tonight, then in the future, you could not build any residential, like over the ground floor retail on lot 7. Is that your thinking?
To be honest with you, Commissioner Montalvo, I haven't even thought remotely about building
But I mean,
additional.
you would in fact then lose that potential because you're utilizing the combined lot area to achieve 67.
I mean, I certainly think that if we were to come forward with a new application or that was ever presented to the commission, that would be an issue. I think, I always try to keep the size of the questions in front of me as small as I can, and I haven't thought too hard about that one. Your original question was, well, how can you use a developed property to get you site area for multifamily? And I think my answer to that was, well, the same way that you could use a developed property with ground floor retail to build higher on top of it. And so I think in this case, and I'm speaking a bit out of turn, but what we've done here is we've taken every square foot or almost every square foot of these 2 lots and said, this is how many residential units you could get based on that, regardless of how they're developed. I don't think you could double count afterwards. So I don't think you could come back if we build the 67 units. I don't think you come back and then, increase above that, because for every square foot of those lots, there's a percentage of a unit that's already been constructed and accounted for. So I don't think it's a situation where we could have our cake and eat it too, in that sense. But I hope that answers your question.
Clarifies. Yeah, thank you.
So I kind of have a big picture question. This might be for staff or Josh, well, your staff too, but so I think there's been a lot of arguments that this should be treated like it's still the whole subdivision or the whole plat or whatever you want to call it. But over time, new owners have come, I'm going to take issue a little bit. They're not imaginary lines. It might be invisible, but they're not imaginary. They're real lot lines with different owners. And I think that so there are new owners in this thing since the original approval. So I guess my question would be, would an applicant like this be able to come forward representing the entire thing like they did the first time and request a major modification that affects new owners that weren't even there to begin with? Is that allowed? Because I think that's the big picture question that I'm thinking about here. I mean, they're requesting something that affects like it's the whole thing, but they've sold huge chunks of it off.
Yeah, I'll take this one, and Josh, if you want to weigh in. So I think a few thoughts on that. So the application is proposing to meet the minimum lot area density through lots 2 and 7, right? As they clearly own those, and so they're saying we have the right to, use this because we own it. But I think an important point, which we've made, staff has made, is that, and it's very clear in the application, that the standards in the code are being met collectively as an entire center. And so when they showed compliance, for example, with the landscaping standards or with there's a big section called the commercial design review matrix. And so it says, you're looking at a whole site, good development or one that meets the code gets this many points out of this many. And there's all sorts of different things. Building size, for example, is one of them, a good example. So what the application, what's included in the application is really a sort of relook at the whole commercial center and re-compliance with the entire commercial center for that commercial design review matrix. So for example, building size, Lot 2 was not included as part of the original approval for demonstrating compliance with that design matrix, but all the other lots were. And so you add up all of the buildings in the commercial center, you divide it by the number of buildings that are there, and you get an average size of the building. And the code prefers smaller buildings because it means they're broken up and it's less bulky and things like that, right? So in the original site plan approval, there's a finding that says site-wide, here's the average building size, therefore we get 3 points out of 5. I'm making it up. But what this application does is it says, we're now applying for a modification to the entire site plan. Here's Lot 2, here's the building size on Lot 2. Here's all the other building sizes. And so when we bring this into the mix, divided by the number of buildings, here's your new result. And so the modification just kind of, they show the building and the site show compliance with the code by bringing in all of the other properties that are subject to that original site plan approval. And so this has been a question of, do these other owners if they're doing a modification to a site plan, do the other owners need to sign on to?
Need to be a
that?
party to it
Exactly.
because it affects the whole site.
Sign the application form.
Right, that's the question.
Right, and we don't have that. The applicant has not provided an application form with signatures from all of the property owners in the commercial center. So potentially that could be another finding of denial, potentially, if you're going in that direction. So that's my one thought, but I think it kind of gets to your question a little bit. I think that's it for now. Josh, anything to add?
I don't think I have a lot to add to that. I think another piece of that to think about is that as Eric was describing, if you're doing a modification to a site plan, there's no way to completely divorce a piece of that site from the rest of it, because you have to look at the entire site that was part of the site plan. What the applicant is proposing to do in addition to that is to say that because this was part of a single site originally, that is why they can use multiple parts of that site for lot area purposes. And they've made the argument that if we could have done this in 2017, we can do this now. I think the important distinction there is that in 2017, you did have all of the owners, all of the property. And so it was one contiguous site. In this case, you have two different parts of the property that are not contiguous. And so you're looking at the entire site for some purposes because you have to, but then you're also looking at just those two portions that are, we have the owner applying to make for the site plan modification.
Let me ask this a different way. Who is allowed to ask for a major modification to a plan? Is it all the owners affected or is it just one legally?
Yeah, I don't know that there is a black and white answer to that question. I think, as Eric suggested, that could be a grounds for denial in this case. I would say, correct me if I'm wrong here, Eric, that has not been how we have historically viewed that part of the code, that it was not unusual for an owner of a subsequently subdivided site plan to come in to do a modification without the owners of all of the parcels in that site plan.
So,
And again, that's not dispositive to the question.
Understood.
That's not unusual.
Commissioner Vance, if I may at least jump in here.
Please. Yeah.
So there's a couple things. First of all, we're only proposing to develop property we own. So the question about, can I apply to do something on somebody else's property? That's not before the Planning Commission right now. The shared parking requirements are entirely normal of pretty much any of this type of multi-use plaza, any shopping center. And the uses on that shopping center do change from time to time. I think the problem with saying that you need the permission of every single subsequent owner to do anything to the original Cedar Creek Plaza approval would, if you took it to its worst extent, which I hate to do, but if you did, you'd say, well, if I want to change my building, do I need the permission of the guy next to me or the gal, 3 lots over? And I don't think that, again, it's one of these broader questions that's really not presented in our application. We have control of the lots we're utilizing. We have, through a shared parking agreement, enough parking, as staff has noted. And, when I was looking back through the original conditions of approval, and basically what they say back in 2017 is that here's the uses that you are allowed to use within the Cedar Creek Plaza. And if you want to change them, you have to come back and ask for permission under, with a new application, presumably to modify the old one. And so I think our approach has been entirely practical, which is to say, these are the conditions we were allowed to develop in this way under a unified multi-use proposal for development, and we want to change that. And it makes sense, and certainly staff has agreed with us on this point all the way through, that we can do that through a major modification. I certainly would be sympathetic to the other point of view if we were proposing to literally do something on somebody else's lot. If I was going to, build a shed on your property or something like that. But I think going the other direction would present practical problems, because then we would have a decision by the city that when you have a shopping center, you need basically every out parcel pad's owner to give some sort of approval if you want to change one of the permitted uses on another pad. So I guess I would encourage a planning commissioner to make a more modest decision on this issue. Look at the 2 lots that we are proposing. We talk about the origin of the use allowances and the size of the lots because we think it's relevant to how we got here. But at the end of the day, you have 2 lots, they're both owned by the applicant. And so I don't think that this issue is really quite as grave as it may seem, especially since, we pulled that lot 3 out of it, which we did not have authorization to use, I think for that reason.
I think on that point, then you're encumbering lot 7 by using the residential allowance on that lot. Then do you have a deed restriction on that lot that says they can't redevelop their parcel because they've used all their allowed density?
That's a good
I
question.
guess that's my point.
I think, no, that's a good question. And I think that if that were a condition of approval, we'd certainly consider that. I think what would make me nervous about that is I don't know if the code's going to change. So I don't know if the density allowances might change. But a lot of times what you could do is have an acknowledgement. I mean, this is typical of transfer development rights in cities that allow that. And basically you say, here's what we did. We can record a covenant on there that said, so much square footage was transferred to this other parcel for purposes of this at this time, and under the codes in effect at the time, no additional development of a residential type would be allowed on that parcel.
Yeah, I'm not sure if I'm proposing it. I'm just saying that this seems like if we're encumbering certain lots, then, or using, because we've never done that before. And it
Sure.
seems,
I think-
so I'm not comfortable going down this path at all, because I know from our history, the one that was behind, will date me, the old Thriftway. Ross, I keep forgetting it's Ross, but Safari Sam's. It was a Thriftway. We had to take into consideration the vacant lot because the other lots were already fully
Mhm.
developed. And that's where, I mean, I guess I would ask the question then, because that would then propose that who owns 2 other lots in a subdivision could then start moving densities around without mitigating the impacts
Yeah.
of that. And I don't know how comfortable I am with that. I'm just saying that it looks like we're trying to shoehorn something in. I'm just trying
Well,
to figure out how it works. I can understand, and this is my conflict, is that part of it, we have to look at the whole site. And the CCNRs are a legal document that enable the parking to use the whole site. I don't know if the CCNRs address the commercial design standards. I don't know if you have a design pattern book in your code that require, because if someone were to redevelop lot 3, would lot 3 have to go through commercial design matrix reapplied to the whole site if they were to rebuild their building? And so it gets really confusing
Well,
from a volunteer standpoint when
sure.
we've got, and we've got a staff report that has given us a direction that's helpful.
Sure. So Chair Simpson, I appreciate that. And again, infill development is never easy. And so 2 things. Number one, it occurred to me while you were speaking that there's another much easier way to look at this, which is this. If somebody comes in and says, I want to build over, say, if they want to build residential over lot 7, right? You're going to have to find that in whatever area, and I mean, this is entirely a counterfactual because I don't think this is going to occur in this particular shopping center again. But let's say they did. I think it's easy enough to just look, okay, what's the square footage within the area that you're proposing and how many dwelling units are proposed there? And I think if we were, if for some reason this were to happen in this instance, you would again look at the site as a whole. You would definitely look at parcel 2 and say, okay, we've got 67 units there. Do you have more square footage that you get you more units that is somehow, adjacent or part of the original lotting pattern? But I think just a unit count analysis would prevent the type of thing you're suggesting from happening, because at the end of the day, when the application comes in, they're going to say, how many units do you want? How many are already there? And what's the square footage allowance that gets you there? And that assumes that the zoning is somewhat static and doesn't change, and we're not looking at this somewhat differently, 10 years from now. But I can't imagine how you could come in after this is done, assuming it gets approved, that you would come in and build more residential on top of the building on parcel 7 under the current code, because you'd have to look at the total number of units, which would include lot 2 and lot 7 versus the total square footage for any new application. I guess what I'm saying is it would be the same analysis as we're doing now. The difference would be we have units in existence instead of units being proposed, and those would count too. It's not like you'd build the units and then suddenly, you have, okay, great, we built those and now that square footage is released again. It's not, the units are there. And then your other question was about, functioning with the CCNRs and
Commercial design standards.
Yeah, the
whether
commercial
they're-
design standards.
And how they would play in for someone redeveloping.
Right. So Ian came up when I was talking and told me that the current declaration requires the consent of all the other owners for changes to the existing structures. I hope I got that right. And so I think that's how it's being handled right now.
So as a holistic site, the CCNRs control the other aspects that the staff was looking at when they were using the parcel holistically.
Yeah. So the way, when I went back and looked at it, originally you started with this 13-acre piece, and then there was a deacon tract. The deacon tract was approved with the uses that are there now, was subsequently subdivided in the CCNRs. The deacon tract is treated as sort of one of the 3 major puzzle pieces, and that has within it sub puzzle pieces that are still encumbered by those CCNRs. And from what Ian told me, when we do changes to those buildings, all the other owners that are encumbered by those CCNRs have to approve. So from a practical standpoint, we're still, it is still the Cedar Creek Plaza. We're still working in conjunction conjunction with all the other owners and all the other development that was originally approved as a unified shopping center.
Okay, so your contention then would be, and you can restate this if you want to, but we don't need the other owners to make this major modification request because what we're requesting doesn't affect them, other than maybe parking, which is dealt with in CC&Rs already. Essentially, or
Well, I think, does
expansion
it
of that.
affect them? I think they would say it does affect them from, perhaps operationally. But the question is, are we proposing something on land they control? Absolutely not. From what I can tell, most of their concerns are about parking, which are handled through the joint parking agreement that we have.
Want to ask one more kind of related.
Sure.
This hotel thing keeps coming up. Posing testimony argued there's a condition of approval. So maybe this question both for you, the applicant, because I've seen, some of your documents say it wasn't. And so maybe you can expand on that a little bit, and also maybe from staff, why that was not a component of this, why you felt that it was not a condition of approval for and doesn't apply. Maybe hearing both those would help me on that part a little bit.
Sure.
Yeah.
So when I saw Mr. Kobach's letter, and again, a lot of what I've learned about this case has been fairly recent, so I've kind of read it all in one big chunk. But when I saw Mr. Kobach's letter, the first thing I did was to go back through each of the decisions to see if there was a condition of approval requiring a hotel, and there is none. So I always start from the simplest position, which is he's saying there's a condition of approval. I'm looking at this, I say, no, there's not. And from what I can tell, it wasn't discussed at all in the original. And again, I don't have an encyclopedic recollection of the hundreds of pages of approvals, but from my first look, I didn't see any discussion in the findings about a hotel. So I asked my client about this, and what my client told us is that when they did the traffic study, they used a hotel use because a hotel use, when you do traffic, and this is going a little bit in the weeds, but I think it bears some explanation. When you do traffic studies, you're looking to find the reasonable worst case scenario. And that's phrased in different ways depending on the type of development. But what you typically do is you want to look at what is the most, the highest generating use that you're talking that could be allowed in this area. And you always look to that as a baseline for your traffic analysis. And so from what I understand, back in 2016, when they did the original traffic analysis, said, well, what's the highest generating traffic use that would be allowed on this property? And it just so happens to be a hotel. That, from what I can tell, is the only discussion of a hotel in the record on the original site plan approval. There was a mention, and I'll see if I can read this to you, Commissioner Bance, but there was a mention in the subdivision about basically says here, no, and it's talking about lot 2 here, no additional lots outside the proposed subdivision or vacant or in the same ownership. Lot 2 may be planned for future hotel, but that has not been entitled for development. Any development of that property beyond grading would require a future site plan application. So that Mr. Kobach's citation and the case that he was relying on there is completely inapplicable to this instance. That case, and I'm gonna see, it's Northeast Medford Neighborhood Coalition v. Cedar Medford. I sat down, I read that case. And in that case, you had a site plan or I think it might have been a plan unit development that clearly said this is going to be a hotel. And they got not a hotel, but this is going to be X land use. And they got authorization in that application for that land use. And what Luba said is, well, we're authorizing it. They're bound by the site plan. So we don't need a condition of approval here to ensure that they do the traffic mitigation related to that particular use. But there's a bunch of ways that this case is different than our situation here. Number one, there is no approval, and it's clear from that subdivision decision that there would have to be a future approval for a hotel. Number two, there was never a request in any of the application materials for approval of a hotel. The hotel was mentioned as a basis for reasonable worst case analysis in the traffic report. And then that leads us back right to where I started, which is there's no condition requiring the applicant to build a hotel. So I don't think that, I mean, I couldn't disagree with Mr. Kobach more on that point.
Thanks. Yeah, Eric.
Just really
Thoughts?
briefly,
Yeah.
the finding in the, I guess it's in a response to that issue that was raised by Mr. Kobach in one of the earlier staff reports, but it's carried over into this most recent staff report as well, is that like Garrett was saying, the original approval, site plan approval did not specify a use on lot 2. And this process that they're going through, a major modification, is the correct process in the code to make changes to a site plan after approval. And so I'd even argue, even if they specified a use and had a bunch of conditions, now they're coming back for a major modification and saying, we want to modify the site plan approval. Here's recompliance with the code. And so, as long as they meet the code requirements for the major modification, they should be allowed to, change whatever was in the original approval. I think what Mr. Kobach is saying is that the applicant and staff have not addressed a condition that it be a hotel, but I agree with the applicant's legal counsel that it's not clear what we would address. There's no clear condition of approval blank. And, potentially resolving the issue that Mr. Kobach is raising would be as simple as saying, we just are not proposing a hotel anymore because the market changed. And here's all of the, here's our narrative that demonstrates compliance with the other sections of the code. So in short, the major modification process, I think regardless, addresses that condition and the change.
And that's a really good point, because the way we would normally, as applicants, the way we would go in, and this is true of pretty much every jurisdiction I've worked in, if you have a condition of approval, you have to go through the same process that you originally went through to remove that condition. And so let's say for some reason there was a specific condition of approval that required a hotel, and all we want to do is get rid of that condition of approval. What would we be doing? We would be proposing a major modification to remove the approval, which I think is what staff was getting at.
Thank you.
All right.
Don't have any further questions.
All right. Any other questions that would raise the level of having the applicant remain at the table versus deliberation? All right, then we will go ahead and close the public testimony.
Thank you.
Thank you very much for taking the extra time to answer our questions. All right. We now have an opportunity for final comments by staff.
Yeah, thank you, Chair Simpson. I do have a few comments at a very dense meeting, so thank you for hanging in there with us, and happy to answer questions for you in deliberations if we can. A few things. I think let's see. To go back to Commissioner Montalvo's I think original question about, how would we see this on lot 7 now that it's been developed? I think the main issue that we're seeing is not that housing can't go above lot 7, in the future. I think the way that we would likely approach that is to say, you have lot area for lot 7 based on the minimum lot area for housing. Here's how many units you can get on that property. I think where we differ with the applicant is that we're saying that housing would need to be on lot 7. It cannot be sent over to lot 2, because when we go into a plain read of the code around lot and lot area, it's just very clear that it needs to be, we can't be, even in the applicant's words, inserting additional language to get to the conclusion that we want, which in their case is looking at the entire site plan. And so I think that's probably the key difference. I just wanted to clarify that, just come back to it, because I think, and it kind of gets to another point that was raised by the applicant about, doing the right thing, approving the housing. I just want to be clear that, staff and the city, would approve any housing in the city that we felt met the code, and staff would recommend approval of any housing that we felt met the code. And so not necessarily about it's about doing the right thing under the code that we have that applies right now. And I think, that's what the task is in front of us. And just on that point as well, we just as a note, we have approved housing in the last 5 years. We approved some just a few months ago. So, but just to go back to that other point, I think that's probably one of the biggest points that I've sort of come to in hearing all of this is that, we're at I'll move on from that point. But I think the other key point that I just wanted to make again is that in sort of response to some of the applicants' testimony is that the main issue that staff is seeing again with recommended approval here is the subdivision. And so, I think we probably agree with them that if it was one site, things would be different. But when they did that subdivision and created those lots, now we have to look at the code through the plain language of the code and apply it in a clear and objective way. And when we do that, we don't see a way to get to the number of units that are being proposed based on the contiguous lots. Number of parking stalls, I do stand corrected on that actually when we bring in the reduction that is permitted in the code, the number of parking stalls that are required for the housing portion is actually 88. It's not 97. So I misspoke in that original staff presentation. So it's 88 once you apply a 90% reduction to it. I think there's still
10% reduction.
10%, I'm sorry. Getting tired here. Another point, not to make it convoluted, but I just want to state it that, we're talking about the CCNRs a lot and sort of how the code relates to the CCNRs. I just want to be clear that the code has to be met, regardless of what the CCNRs say. And so even if the CCNRs say that the buildings, building modification has to be agreed to by everybody, that's great. But you still have to meet the city's code in addition to that. So we can't lean on CCNRs to address an issue that the code, needs to address or that they need to show compliance with under our code. They're two totally different things. And then the last comment is that there is definitely an easement on lot 2. My calculation, just based off the dimensions, we had it at about 2,000 square feet. And so when you go to the definition of lot in our code, it says, lot area shall be determined by lot area minus any right of way and easements providing access to other properties. And there's very clearly an easement on lot 2 that provides access to other properties. And again, that has not been removed from the calculations. So that would be an issue, even if in staff's mind, that would be an issue, even if planning commission were supportive of using lot 7, that should be corrected through the proposal. And that is all I have for you.
All right, final comments by staff then. All right, questions of staff, if any, by the commission for this process in front of us. So we are open for deliberation.
Chair, so remind me, we don't need a motion before discussion, correct?
We do not.
Okay, just want to make sure. I can start.
You can start if you have a.
Since I'm already going, so
You're on a roll.
I think we've heard clear and objective a lot in this process, and especially of recently in other applications. To me, there's nothing more clear and objective than this does not meet code. There's a lot of other talk going back and forth of, if this were done at this time versus now. My thoughts with, things like that are, well, if we were judging this based on the code that we have now versus the time when this was submitted, it's, we have parameters that we operate within. That's something that makes being on the planning commission, pretty much boring a lot of times because there's not a lot of discretion that we have, outside of this or that. I think it makes our job easy in a lot of cases because it's just a simple question of, does this meet code? And I believe the reasons why it doesn't meet code are also very clear and objective as well. So for myself personally, I don't see how I could approve this application in its current state.
Are you wanting to make comment or wanting to entertain a motion from?
Can you discuss?
Okay. Yes.
Just quickly before you, I guess I would just concur with the applicant that I do think that we're in agreement at 90% of or 99 or whatever it was % of the issues. And going to the applicant's comment about, I support aging in place and I support needed housing, and needed housing of this type. But I agree that I think the concept proposed of shifting or aggregating the lot area in the way that you are is not clear and objective, and I don't see where it does meet the intent of the code. So that is all I would add.
I like your word dense. This is a dense, complex one. And I also appreciate all the testimony in the applicant tonight. And I can see where you'd say that both sides have arguments that are not, I think these are not dumb people. These are smart arguments on all sides. And venturing into a category, even my question earlier, just is not that, it's not abundantly apparent, who can apply for what and in all cases, but I tend to agree with what you guys are saying on this, and I'm understanding what Mr. Rutledge presented tonight. It's a major modification. I think it does affect other owners out there, probably more than is suggested, but even so, I mean, it's almost kind of like looking at this like it's a whole subdivision deal, but also we're looking at just think about just the lots. It's like, okay, well, you can't have the benefits of both sides of that entirely. It's just, are we looking at the lots or not? And I think in this case, we are looking at the lots. That's what's being requested. They're not contiguous. I can see the argument of, why just one part of code, applies or doesn't apply when everything else would. It's just a bit of a challenge to get there. And I'm worried about the easement component as well. And I think that also is a concern. So I think there's too much to get past on this one for me.
I
it
concur
is.
with the rest of the commission comments, which is we're tasked in a quasi judicial area to make clear and objective decisions based on clear and objective standards. And in matters that are this complicated, especially when we have lawyers on both sides of us presenting very, very complicated items. And we rely on our staff and the legal advice that they've been given through the process. And not only Josh, who's here this evening, I know that you in your staff report presented that another legal consultant was advised. So I don't think I could formulate an argument that would be better than what our staff has already presented to us. And I think we're doing our job by supporting the staff and making a decision in a complicated but in a clear and objective way. So I would entertain a motion to.
Before we do that as conditions, do we want to talk about conditioning or not the condition, but another reason for denial being the app who's applying or not? That kind of came up.
Another reason for
Denial being that not all the property owners applied.
I don't think it's necessary. I think from my understanding, it's best to just make your denial based on what is most concrete, clear and objective. And I think what is in the staff report fulfills that, and anything beyond that gets a little more debatable.
No opinion. I was going to ask about conditions for the parking because I want to ask the question, but if we're going down the path of denial based on the recommendation from staff, I don't want to reopen a parking question about whether or not they have the legal right to use residential lots on the non-Deacon parcel as part of their shared parking reduction. It raised some concerns for me during testimony, but again, I go back to rely on the staff and the legal opinion they gave us in the staff report is that the parking math works from a planner's perspective. So I just have to rely on planner math. So
Is it appropriate? Can I?
You can take that as a vague question.
Okay, so just sort of on the discussion at hand now about, I think, other findings, that are not called out in terms of non-compliance in the staff report. I don't know, Josh, maybe you can give some guidance on if there is an appeal, goes to LUBA, that type of thing. Is it best for Planning Commission to sort of call everything out now? I mean, of course, if you guys actually feel like there are other areas that are not met, if we can weigh in on whether or not they should call those out, or should it be limited to a few things, or what's the best approach if they're thinking that there might be more standards that aren't met?
The decision should reflect the reasons for your reaching the conclusion that you're reaching. So if there are other reasons that you want that you think the application should be denied, then we should include that in the decision, the written decision. A caution would be that we're kind of developing reasons during the course of this hearing that maybe haven't been fully vetted, and that you have reasons for denial in the staff recommendation that have been vetted.
All right.
Sufficiently answer the question.
Yeah.
And I'm happy to answer. If you guys want to go into details on anything else, parking, I'm happy to do that if it's needed.
No, I think you vetted it out well.
Yeah, because I also have a concern about the secondary commercial, clearly secondary to commercial buildings component. If we're just talking about these in terms of lots, the application as well. But I think it's okay to stick without getting into all that murky water you were just talking about. That has not been, we discussed when we talked about it, but not length. So I think we can go through with what staff has recommended.
I am. And Eric, I just want to make sure the standard language in denial motion referring to findings of fact and conclusions of law included in the staff report, that is all encompassing enough. I don't need to include the specific development code as your final slide in the presentation listed, correct?
I think it'd be good to include those, probably, reference the specific sections that are.
Include those, Josh? Okay.
Yeah, would you need the slide back on, or?
I have a picture of it. Okay. I move the Sherwood Planning Commission deny the application for Cedar Creek multifamily project number case file LU 2021-009 MM and adopt those findings of fact and conclusions of law included in the staff report addressing non-compliance with applicable criteria, including development code sections 16.12.030, 16.22.020, and 16.90.020 D1.
There a second?
I'll second.
All right, it's been moved and seconded that we deny application LU 2021-009 Cedar Creek multifamily major modification based on the code criteria in the motion. Is there any further discussion? All in favor, say aye.
Aye.
Aye. Opposed? Motion carries. Thank you very much for everybody's time this evening. All right. So regarding the packets and stuff, we want us to leave all of our the 3-ring binders and the
You still have more commissioner comments and you
Yep,
want to go
yep.
through the rest of it?
Yep, while they're clearing their
I see.
stuff up, I just want to make.
Yeah,
sure
if
we
you,
all
if all the
address-
commissioners can leave the packets, especially the application, in case there's an appeal, we can
Yep.
send it on, yep.
Okay, so blue bags left here for Colleen to work on. Getting them all upstairs.
I shouldn't have to drive around to our houses anymore and pick them all up.
All right. Commissioner comments. Anybody have any comments for this evening?
I think so.
I have a concern, so. I don't remember if it was. Well, it was this morning a little bit, and then Friday morning, I think, was coming from Walgreens in the morning. Heading to the post office. And if you come from Walgreens and try and turn left to get to the post office, the Dutch Brothers driveway was backed up all the way to the intersection. And when I looked over there, there were gaps in the cars and the guy was taking orders closer to the driveway. And it was actually physically blocking the street where you couldn't turn left at the lighted intersection. And I think that needs to be, it was early morning. I'm sure it had to do with school traffic and everything like that, but I think we should look at that as a safety concern to see if Dutch Brothers can get some traffic flow to the other side or get people coming in through the plaza, so they're not blocking the street there at that intersection.
Backed up all the way to Sherwood Boulevard, and so you were turning from Sherwood Boulevard onto Langer, I believe.
Yes, I was.
So a couple of things, maybe 3 things. One, I will mention that to our police captain tomorrow, just as a heads up. 2, we have a traffic safety committee now that you can submit comments and concerns to, and they can dive down a little bit more and decide whether or not there needs to be enforcement, whether or not there needs to potentially be
nice.
some discussion. And so I encourage anybody to fill something out, a complaint, and then every month they'll have however many new ones there are, but they really dive down into that. And then I guess the third is if something happens where maybe there's something we need to talk about from a planning standpoint or engineering standpoint, we can certainly do that as well. But I think the enforcement and traffic safety committee is probably the best first step, rather than having planning try to reroute it. Yeah, I think that would be, there might be some options. Enforcement just might be like the police officers may need to on occasion say, stopping in the middle of the road and figure it out, or have a conversation with the staff at Dutch Bros.
Yeah, I think that would be the easiest, is just have them be mindful that if they get backed up into the street, they have to take an action to make it more safe.
So the way Dutch Brothers is set up, it has 2 drive-throughs. So if it backs up to 1, then the logical thing, rather than blocking the road, would be to go around to the other drive-through. But if logic were a thing, then people wouldn't be running stop signs in our town all the time.
Yeah, absolutely. And that was a frustrating, the last person that's blocking the road could have done that, but they didn't. And then you get two more cars that are just trying to use the roadway. And so I just thought I'd tell Erica and she'd fix all my problems.
That's usually how it works.
It is. So, all right. Well, one last thank you to Julia for her years of service. You are going to be very much missed.
I think the perhaps the worst part about leaving is the attention that leaving gets you. But thank you very much.
You have served this community well, and you will be missed. So, all right.
And Julia was the first person I interacted with before being appointed, and it was like, I just remember, just a positive interaction that's stuck with me. So
Nice.
yeah.
And thanks to staff, this application is so complicated, so long. You guys put a ton of effort into it. So appreciate you doing all that.
Yeah, you guys have had between the Commerce Center and, we're still getting another application back that's still in review, so we shouldn't talk about it, but you guys have had a busy land use docket, that is for sure. And appreciate your hard work. So yeah, we'll stay at it, and you guys have to be on that side as well to look at these. So we'll keep going.
On that note, I just want to also say, thank you for being fluid with our concerns and really looking into them and really getting the analysis required to, for if staff changes it's mine. I think that's something that you are fully within your right to do. I don't think it's one thing or another. And I just, appreciate that support for us as commissioners as well. So.
What's up next time? Is there a public hearing next time too? Can't remember. Next one has 3.
No,
Two.
2,
So-
3.
And I just want to reiterate too, we are not slowing down in
Yeah.
current planning. So, for probably over the next couple months, I expect, probably at least 2 hearings for each meeting.
This is summertime. We're gone.
Do you double our pay for all the?
God.
Heck, they should triple our pay. Why
Yeah.
not?
I think that's why you get special treats from calling in.
All right, well, we all have our sample motions and we have the forecast. So the next meeting on June 14th, it says that it's a work session, but it is not on the agenda that was sent out, correct?
Correct.
All right.
Can city council approve anytime there's 3 hearings in one night that it automatically comes with dinner for planning commission? Thank
We
you.
will have dinner for you that evening.
On June 28th, we have 3 hearings. It says it's 7 PM, but it's actually going to be 6 PM. So would you send out a revised
Yes.
meeting agenda
Yes.
forecast so we're all?
Yeah, sorry, and I know you were sort of joking, but there is a budget for that. kind of thing. And you guys work really hard. You give so much time, and I think the least we can do when we're asking you to do 3 hearings in one night is to give you a little food. So we will take care of you.
Okay, so I'm leaving them. Okay, so we'll go ahead and adjourn the meeting if there's no more planning commissioner announcements.
My goodness, I think I'm actually not here on the 28th.
Yeah, me neither.
Oh,
I'm
Yeah.
busy.
is the council going to approve our 7th commissioner at the next meeting?
Yes. it
Or
is.
it's on the
it's
agenda?
On the agenda slated on June 7th.
Okay, so they'll hit the ground and then we'll hit them with books and binders. Good, all right. All right, then we're,
One more thought with Commissioner Vance being out, it might be good just at some point before we get into this busy June, just to check on calendars and schedules.
Yeah,
Make sure
That's what I was doing.
we have a
all
quorum,
that.
for all these meetings. So maybe we'll check in with you guys.
I thought it would be, but the 4th Tuesday is really late in the month in June, because June 1st is a Wednesday. So, well, that's how it goes. Okay. I'm out of town that week, that whole week.
You know, you can attend via Zoom.
Can I?
If you really gonna miss us.
That seems like it works really great.
We need quorum. We'll make sure to, we'll know where to find you.
Oh, good.
All right,
All right.
meeting's adjourned. Thank you. Yes. I don't know what he was thinking. All right, so I am leaving. Took out my important notes.